Thanks for joining today's video, going through the Colorado contract to buy and sell real estate. So this is the contract as a buyer agent you'll submit on behalf of your clients to help purchase a house, and that you will be reviewing when working with the seller to see if it's the right offer for their house. So where this could be found is in any of your signature platforms, your DocuSigns, your CTME down in Denver, your dot loops, DigiSign. It's all going to be the same one. Make sure you are using the current approved contract. So I make sure I find mine at the Colorado Department of Regulatory Agencies, also known as DORA. And you can just Google DORA real estate contracts. So that's all I did. Got it to here. Scroll down. Oops. Made a click. Scroll down here. Commission approved contracts, and here they all are. So listing contracts, sales contracts, that's where we'll be going through disclosures and addendums. So we're going to go through the contract to buy and sell residential. And here we are. So this contract is, as you'll see, 18 pages long. I choose in my platform to choose a version that does not include initial boxes at the bottom. If both parties leave the initial boxes open, then nobody has to initial them. As soon as one side initials, everyone has to. That adds quite a bit more fields, and it's not required by the state of Colorado. All right, so going into it, I'll talk to my clients and tell them that this is a legal document prepared by the state of Colorado, their attorneys, and it's not prepared by me, my team, or my company. So that's for whoever's watching this, just know that. And we want to, again, make sure that this is the current form for the current year. So we have, of course, all the sections that we'll go through is what I'm going to touch on, and we'll skip the ones that won't apply to a traditional residential transaction. You'll notice on this that you can do leases and commercial sales, farm sales, things like that, all with the same document. So we'll get started here. So we have today's date that we'll put in. We have the buyer's name as they want it on title, whether that's no middle initial, a middle initial, or a middle name. Just know that everything has to be congruent through the whole transaction. Then we will ask them if they want to be joint tenants, tenants in common, or other, which is typically for a single buyer, tenants in severalty. So we would check that and write tenants with an S in severalty. So joint tenants is equal ownership, typically a couple, a married couple, or a couple of buyers would choose this option. They have equal and full ownership with survivorship rights. So if one passes away, the other becomes the full owner. Tenants in common is going to be typically business owners that will want to purchase together, but you have a separate ownership that is saleable. And make sure you look up those definitions to get the full definition there. But that's the first thing after the name. Then we have the seller's name that I typically just go and copy and paste from public records. We put in the county and 2.4, so make sure you're looking up what county it's in. Under that, in this big space, we'll put in the legal description. I never copy and paste it from the MLS. I always go into public records and copy and paste it just to ensure that without a doubt we are selling the correct property. So don't make that mistake. Put the street address here, street address, city, state, zip, pretty simple there. In the inclusion section, everything in the property that is physically attached is included with the sale of the property unless otherwise noted. So they have a huge list of items here that covers most items that you would think about. And then, of course, you can check solar panels, water softener, security systems, satellite systems. If those things exist, know that satellite dishes and such will typically just stay with the house, and it's included with your next purchase of cable and such. All right, garage door remote controls. I always just put any /all. That way that any of them that they have, they're going to include with the sale. All right, personal property. Again, personal property is not included with the sale of a property And that's typically done outside, similar to a Craigslist transaction, so separately. Otherwise, it does increase and change the taxable value of the house. Make sure you consult with a CPA on that if you have questions. Parking and storage facilities, if there's a detached garage, shop, shed, anything like that, make sure it's noted here. An attached garage is obviously attached to the house and included. And 2.6, exclusions. Anything that's attached that needs to be physically detached. So might not be thinking of certain things that Mr. and Mrs. Seller have, such as their prized rose bushes, right? Someone might want to bring their flowers with them. They might have a barbecue that they've fixed to the ground that they want to take with them, some curtains, curtain rods, some shelves on the wall that they've attached with a screw. So just go through in depth and take a look around the house. Make sure you give them some suggestions of things to be thinking about. Last thing we want to do is include something with the sale that should not be included. And in my opinion, I think that if you make that mistake, you're responsible for buying that for your client. But that's just my thoughts. All right, then we're going to ask if they have any wells on the property, typically not in neighborhoods, if they have water rights or mineral rights. If they don't know, they probably don't have them. And if we don't note it, it's going to be conveyed with the sale of the property. Section 3, we're going to have the dates and deadlines section. You can very easily, as I pull out here, go and find these dates and suggested dates on the internet. If you just Google real estate contract Colorado suggested dates and deadlines. My title rep has given me this cheat sheet here, so it has all the dates and deadlines suggested. You can ask yours for one of those as well. After a couple transactions, you won't need that any longer. But I'm going to go through the averages for you and the things that are suggested, help you make quicker contracts here in the future. So alternative earnest money deadline, this is 2 to 3 business days. So if you write days and you write an offer on Friday, get it accepted on Friday, then Saturday and Sunday are days, but those days are not open business days for the title company. So make sure you're specific in here, 3 business days, for example. All right, so day and business day will make a difference here. Title number 2, 3, 4, 5, and 6 are typically 7 days, 9 days, 7 days, 9 days, 10 days for 2, 3, 4, 5, and 6. 7 I have not had to use yet in over 5 years. Owners Association, I typically give them about a week to 2 weeks, depending on how long the contract is and how competitive we want to make it. But I always check the MLS to see if they've given us a website and if that website has already provided public access to the documents that we need. So I just base these dates based on that. And I'll try and pair it up with something else like due diligence, for example, down below. And then I'll give it 1 or 2 days. For me as a buyer's agent, I want to give 2 days for my buyers to go through that, read up, and I'll give them suggestions. Make sure if you want to park in the street or park an RV that you check the rules. If you want a pink house, check the rules. If you have a pit bull, a Rottweiler, German Shepherd, a dog of one of those breeds, make sure you check the rules. Especially in condos, that's more important. Seller's disclosures. Make sure that they haven't already provided it, but I typically give 3 to 5 days for the seller property disclosure, no more. Lead-based paint disclosure is only required if the house is built pre-1978, although I do require it on my sellers on 1979 just because you never know when the permits were pulled. New loan application, I'm not writing an offer unless it's already been done. So I write complete because writing an offer without your buyer being pre-approved is pretty silly. New loan termination deadline, I'm going to do that typically 5 to 7 days before the transaction ends, either the same day as the appraisal resolution deadline or the following day or 2. Then I usually skip these next 2 credit ones, don't put anything in there. 16, 17, 18, 19, typically leave blank. There's typically never reason to fill those in. Section 20, 21, 22, these ones are for the appraisal. If you have an FHA loan, it does not matter. Those dates are void. But for any other type of loan, we're going to talk to the lender and ask them how many days they need. Right now, as of October, November 1st, here 2021, VA loans and FHA loans are taking just a couple of days, where in times past they've taken 2 to 3 weeks, maybe even more. So just consult with your lender on there, but I give it a minimum of 3 weeks typically to put those dates in. So I'll do 3 weeks out for the appraisal, add 1 day, add 1 day. If it's a weekend, add 2 days. Survey, leave that up to the buyer. If it's in a regular neighborhood with pretty defined lots, typically you don't need a survey. But if the fences look off, you have something to check on, maybe it's an acreage property, we're going to give that. Typically, they're booked out at least 2 weeks. I know in my area right now, the surveyors are booked out 4 to 8 weeks. So contracts are typically not that long. Use your judgment. Inspection and due diligence period. The inspection period is typically 7 to 9 days out. However, I want to get it done as soon as possible and make sure that there's no time that's just wasted. So we want our buyers to find a house to get through the process. Same thing with the seller. We don't want a buyer extending that 2 weeks or 3 weeks out, because then we're just losing days on market if they find something and terminate. So I'm going to call my inspector at day 1. As soon as it's been approved and accepted, then I'm going to call my inspector and say, when is the soonest you can be out at this house? All right, so I typically put that for my buyers. I do give them that 7 to 9 day period or 7 to 10 day period, but I'm going to get it done as soon as possible. So that might be 7 days, 9 days, and 9 days for the termination and resolution on the same day. That's just how I choose to do it. Some people will do like 8 days, 9 days, 10 days, 1, 2, 3. Property insurance termination deadline. I typically give my buyers about 2 weeks to get that done. I'll do it maybe Friday and 2 weeks from now. And that's just them calling their lender to make sure that there's no premiums for flood insurance or fire insurance, things like that. Due diligence documents delivery deadline. That portion here is going to be pretty easy. You'll define later in the contract what you want them to give. For example, any existing inspection documents, engineering reports, invoices to large work done on the house, or if something was replaced, a warranty on existing items, a roof warranty. There is some copy and pastable forms or addendums that you can use to put in the additional provisions to make sure you're asking for the right documents. Anything that's a physical known fact, then they're required to disclose. I just put it in there anyways as a reminder. So I would give them about 2 weeks max on that, and then plus 1 day, plus 1 day. Conditional sale deadline, that's only if they have a house to sell, and you're going to want to make sure that you put that in writing so that they have an out if their house does not sell or does not sell on time. And that's going to typically be the closing day or closing plus 1 for this house that they are currently selling. Lead-based paint termination deadline, I've never filled that in personally, but that's your choice. If the buyer wants to terminate or have an extra out based on the lead-based paint, if it's an older house, just know that any extra dates and deadlines in there will not make your offer as strong. Closing and possession, that's based on when your buyer is going to get possession of the house and make it theirs. Typically, that's upon delivery of deed. As soon as the money transfers at the closing table, they will take possession of the keys and of the house, but that is negotiable. So if the seller needs an extra day or 2, or they've disclosed they need 60 days to find a replacement property, just know if your buyer does have a loan, that cannot extend past 60 days on paper. So there you have it there on the dates and deadlines. Otherwise, if you do need that post-closing occupancy or a lease back from the seller, make sure you have a post-closing occupancy agreement attached to your offer, signed by all parties, because it's much harder to negotiate down the line. And if the seller chooses to say no later, you're SOL, they're getting a hotel or an Airbnb. Acceptance date and deadline, I typically will base that based on when the listing agent says that they're going to review offers. But if we're making a great offer, highly competitive, we're making it early in the afternoon, I'm typically going to give them till end of day, maybe 6 or 8 hours if they say that their seller can respond in that time period. Worst case scenario, we're going to resubmit. Section 4 is the price and terms. So we're going to put in our purchase price in the top line, same on the total line. So all 3 of those should be the same. Our earnest money is going to be what is advertised in the MLS as a requirement. Then we are going to have our cash at closing, which is the down payment that is required by the lender, minus earnest money, and then subtract those 2 from the purchase price, and that's your new loan amount. Seller concession, 4.2, below, is only needed if your buyer is asking for cash back. Just keep in mind that anything that you put in here, so let's say $2,000, is basically going to be your total purchase price minus $2,000. That's how a seller will look at it. All right, section 4.3, earnest money, and that's going to be dictated by the MLS, and it's going to be a personal check or a cashier's check. always suggest that your buyers use a cashier's check, because if they need to pull out of the offer, a personal check may take up to 14 days to clear or release, and a cashier's check is immediate. In the buy section, line number 2 here, that's going to be the title company's name dictated by the MLS. All right, moving down. Section 4.5 is the loan. So check what type of loan they're using. Leave it blank if it's cash. So if it's conventional, check conventional. FHA, check FHA. I always have skipped these next sections as they don't apply for seller financing. Section 5 is all just disclosures. I don't go through them because they've already gone through their applications. I just let them know that there is a loan objection deadline if something does change. Section 6, we're only filling this in if there's a FHA loan involved, where we'd put the purchase price amount under 6.2.2. Cost of appraisal, typically check the first box for buyer to pay for it. If there's an owner's association, section 7, then again, make sure your buyer is thoroughly reading through the documents. You are responsible if you make a mistake and there's something that's not good for them and their needs. And then we're going to make sure that they know what the HOA amount is, or if there's a metro tax with an HOA fee included, make sure that their lender knows that those values are there. Section 8, typically seller selects the title insurance company, but if you want to make it very competitive, you can have the buyer select the title insurance policy and company. Just know that the buyer will be required to facilitate that owner's policy, and that can be $1,500 to $2,000. Owner's extended coverage, 8.1.3. I always recommend checking will on there, and that's typically between $175 and $350. By standard, if there was one, it's one half buyer, one half seller. If you're trying to be more aggressive, buyer, if you have a great offer and you want the seller to cover a couple $100 of something, you can check seller. But that's a negotiation point in the contract that I would note. Whatever is checked in my offer cover letter, which is just the email with the bullet points of what's in the offer. All right, these are all disclosures. As we go down, section 9, you'll fill in if you're going to do a survey. All right, section 10, seller property disclosure. Just know that all material facts are required to be disclosed by the seller that are actually known, and anything that they do not disclose. I mean, even if they are leaving because they hate the HOA or there's some crazy rules they don't like, if that's their reason, they have to disclose it. If there's a crack in the basement they covered up, they have to disclose it. Due diligence, 10.6. This is where you're going to write in the second section, any information that you want the seller to provide. So I would always write it as seller to provide any documentation in their current possession. And then I fill out what I want them to provide. Again, you can have a copy pastable option here from your brokerage or managing broker if you have one on staff. Section 10.6.1.1 above, if there's a lease and you need lease information, you would write that there. All right, moving down. Section 10.8, source of water, pretty self-explanatory. Either the buyer does or does not have a seller's property disclosure in possession. It's typically provided by the listing agent or in the MLS. There's no well if there's no well. Buyer does or does not acknowledge receipt. Let's see. All sellers are required to have a working carbon monoxide alarm or smoke detector in the property. If they're selling in Colorado, they're required to have a lead-based paint disclosure with the sale of the property fully executed upon the purchase agreement if it's prior to 1978 built, and if there was ever meth cooked or smoked in the house, then they're required to disclose if they know. All right, closing instructions either are or are not executed with this contract. That means if they're given to you prior to writing the contract, then they are, or they are not if you haven't gotten them. Closing dates designated by mutual agreement typically. Transfer of title is more often than not a general warranty deed. Sometimes there's a special warranty deed required if there is a trust maybe or some other unique scenario. Seller will be required to pay all liens and encumbrances on the property if there are any, unless otherwise disclosed. Will come up in the title report. Section 15 in the closing costs. These are negotiable. So these are all things that are part of your negotiation with the seller when writing your offer. So the closing services fee, which is typically $350 to $400, can be paid by the buyer to be competitive. You can have the seller pay it if you have a really outstanding offer that you know is going to be above everyone else's, or split in half. I would say standard, if there was one, would be 1/2 buyer, 1/2 seller. Status record and record change fees, again, negotiable, whether you want the buyer to be more competitive or have it split. Transfer tax, same thing. Transfer fee, same thing. The community association might charge $100, $200, $300 to transfer in the new owner's name. Water transfer fees are rare. Just make sure you know if they exist in your area. Same thing with sales and use tax. I always ask every single buyer for 15.8.1 if they are a U.S. citizen. I don't care what you look like, smell like. I always ask everyone just to be sure, because their taxes are greatly affected if they are not a U.S. citizen. So I just want them to be in full disclosure and have the opportunity to research if they are not. And you can never be sure where someone was born and hold their citizenship. Section 16, always check most recent mill levy and most recent assessed valuation. Know that those come out every odd year around May. So 2019, 21, 23 around May, June. And there's a short window for them to fight that when it comes out. Side note. Section 16.3, association assessments. Saying if there's a special assessment, maybe the HOA is repainting the buildings and changing the roofs, and all the owners are required to pay $800 by a certain date. If you, regardless of if you know of anything, I typically check that the seller is responsible for paying that assessment that was given to them prior to putting their house on the market. Of course, if you know what that assessment is and you want to be really competitive and they have not paid it, you can choose to do that. Just know what you're signing. Possession, this fill in the blank up at 17 is showing what the seller is required to pay to the buyer if they do not move out on time. So typically you want that to be a dollar amount that is more than a hotel, because otherwise what if they choose to stay and your buyer's SOL? Just know it has to be, as far as I know, received in small claims court if they choose not to pay. But I always put $250 or $350 per day, because that's not so desirable if someone has to pay that. Obviously, at a higher price point, that might go up to $500 or $1,000 per day. Just know what you are signing, do the math, talk to your clients. Section 18, computation of period of days deadline. This is saying that any date or deadline in this contract that falls on a weekend or state or federal holiday where the title company is closed, for example, will or will not be moved to the next business day, so that the contract's not canceled based upon a holiday. So I typically always check will, just to give that leeway for all parties. No one wants that. Everyone's human. Just be careful writing your date so you don't fall into that category. All right, disclosures. Walk through here. Buyer, upon reasonable notice, has the right to walk through the property prior to closing to verify the physical condition of the property complies with this contract. So making sure there's no holes in the wall from couches, legs being punched through, make sure the power's on. We had a sale where the power was not on day of closing. Found out that there was a grounding wire that was swinging in the attic and touching a nail every time it passed, and it was tripping the power. So easy fix in that case, but sometimes it's not so easy. Make sure there's no backed up sewers, things like that. Once you take ownership, it's your responsibility to fix. Section 20, as is in the buyer and seller exclusive agreement, recommendation of legal and tax counsel. I'm not a lawyer. I'm not a CPA. Neither are you, unless you are. So please just recommend them that you're not that person, but you can recommend them to somebody. Time is of the essence for these dates and deadlines. All of these dates and deadlines are hard dates and deadlines. If the buyer misses one, the contract can be terminated. However, if one is missed and both parties agree to move forwards, you can also do that. I was instructed never to check the specific performance box. Just makes everyone's life quite a bit more difficult versus the alternatives. Legal fees, costs, and expensive. If someone needs a lawyer, they hire them. Whoever loses pays all reasonable costs and expenses, including attorney fees, legal fees, and expenses. Mediation is the free version of getting an attorney. Earnest money disputes, somewhat rare, and the buyer is typically in favor. The state of Colorado is a buyer-friendly state, so the buyer has many reasons, nearly unlimited, to get out of the contract if they want to or need to. Just make sure you follow all the correct guidelines. Talk to your managing broker if you have a specific circumstance you're not sure about. Section 25, termination, rights to terminate. Once a seller is under contract, they have very few exit points. Once a buyer is under contract, they have many exit points, but you want to use them sparingly. Make sure you're getting under contract only if that buyer is motivated to close on the property, and you let them know that their offer price is based on what they're willing to give up or willing to lose it at. And it's the highest and best. Make sure that they know that they are getting into a legally binding contract with quite a bit of money at stake, and that it should be their intention. It needs to be their intention to follow through with the transaction in case something egregious comes up. This is the whole contract, especially making sure you note that any of these other documents below are included. So, for example, if the lead-based paint disclosure is required, if a post-closing occupancy agreement is going to be in there, that it is noted as a attached document in Section 31. Section 27.2, I put in here electronic delivery. So you can use Dotloop, DocuSign, CTME, one of those programs. The buyer or seller is always going to be given notice of acceptance, rejection, or counteroffer in a timely manner. And Section 29, this contract is made in good faith. So everything that's written in here is the intention. No writing conventional loan or cash if your expectation is that you will be switching to an FHA loan. You can use a different type of loan if your circumstances change or if it ends up being better, but your intention has to be used. You don't want to double cross someone or blindside somebody when someone else might have had a better, highest, and best offer. That is not good ethics. Additional provisions in here. Be very careful what you write in here, as you are not an attorney. So make sure you use approved language, and you can find quite a bit of it in CTME if you use that, or check with the managing broker to see if there's a bank of approved additional provisions written by an attorney. Otherwise, you might be jumping into practicing law when you're not a lawyer. You can get yourself into some hot water, can make some claims that are false. So just be cautious there. And note that every house is sold as is in the state of Colorado. So no need to write buyer is purchasing as is here because it's already noted. Feel free to write that in your email, but it's not needed here. Again, other documents here, post-closing occupancy agreement, lead-based paint disclosure. If they're included, they are all part of the contract. I typically leave 31.2 blank unless we need an addendum. If you're on a team and you have to write in your teammates' names, then you just see addendum A and write team members have access to the contract and client details and write their names. I don't typically write in all the information for the buyers, but I do phone number and email address for the title company to have that on file. I always go in and make it easier on the listing agent, so I'll get that here in a second, but make sure you fill out everything as it stands to you. So if you have an earnest money deposit prior to the offer being accepted, probably not. So it's going to be typically does not acknowledge receipt at the time of making the offer. Whether you're a buyer's agent or transaction broker, I suggest you doing this more often than not. Typically, you're getting your commission from the listing brokerage firm as it's advertised in the MLS. You're going to put your broker's name, your brokerage firm license number, your broker's name, and which is your name and your license number. Note that the firm's license number for eXp Realty can be found in the eXp Workplace group, which is in expenterprise.com. In the Colorado State group, it is pinned to the top and under Files. And you can also go into DORA, where your license is held. It will tell you your license number and the brokerage's license number. You can also find that for the other agent if you choose to fill it in for them, which is where I get to next. So for the other agent, if it's not already filled in or you can't autofill from the MLS, I will go into DORA, look up their name, look up their license, and I will fill in this information for them. So all they need to do is sign. The easier we can make it on other people, the easier we might get our offer accepted. So that's it. About 30 minutes there of explanation of this contract. There's a lot to know. Read the whole thing over a couple times so you know all the verbiage, so you know what's in there. Be an expert of this contract because ultimately your reputation and your career rely on it. If you have any questions, let me know. Let the managing broker know. Know that for EXP there is a weekly contracts class that you can go to with one of the managing brokers. So please attend that, especially if you're a new agent. You need to be an expert at these contracts. You need to know what you're signing, what you're having your clients sign. You need to know how to answer the questions. These are legally binding contracts, so you can be held liable in a court of law if you make a mistake. You can lose your license. You can be fined an incredible amount of money that you probably or might not have. But most importantly, our job is to look out for the public. That includes our clients. That includes the people on the other side. So please put a lot of time and effort into knowing these contracts. Thanks for watching. Let me know if you have any questions, and look forward to seeing you in the next video.